The Attorney General, by way of a press release issued to members of the media on Monday evening, expressed that the judge's ruling was a good one, while he posited that Justice Harnanan identified two main issues for consideration in the substantive matter. Those being whether the 2021 amendments to the Fiscal Management and Accountability Act, FMAA, undermine the independence of those constitutional agencies listed in the third schedule, and whether they are in conflict with the Constitution, as well as whether the 2021 budgetary process was also in conflict with the Constitution. The Attorney General cited that the learned judge agreed with the submissions made by him, noting that it is the role and function of the executive, specifically the Minister of Finance or any other minister designated by the President, to lay before the National Assembly the estimates of revenue and expenditure for the country, according to Article 218 of the Constitution of Guyana. While the Attorney General is making those assertions, however, Nightly News spoke with Shadow Minister of Legal Affairs in the National Assembly, APNU-AFC's Royce Ford, who posited that the judge's decision reflected that the 2021 amendments to the Act was unconstitutional, and that ruling vindicated the APNU-AFC's position on the amendments, as reflected in court documents filed by him and his team.
That the Fiscal Management and Accountability Act of 2021 is unconstitutional.
Ford told Nightly News that the court rejected the submissions made by the Attorney General on the substantive matter.
The court's decision also rejected the submissions of Anil Nandlall that the amendments made in the Fiscal Management and Accountability Act were constitutional. It is clear that Anil Nandlall is incompetent and has provided poor advice to the installed government.
The Attorney General acknowledged via the release that the 2021 amendments to the FMAA was intended to reverse the 2015 amendments made to the Act by the APNU-AFC government, while he also noted that the court has now redirected the budgetary process for those constitutional agencies to their proper course. The fallout over the amendments stemmed from the notion by the APNU-AFC that constitutional agencies listed in the third schedule of the Constitution of the Cooperative Republic is being subjected to the control of the minister with responsibility for finance, and further that the government has breached the law with regard to the allocation of funds for constitutional agencies. The government is asserting that that is not so, and that the process by which budgetary allocations were made for constitutional agencies was a lengthy and quite tedious one. Article 222A of the Constitution clearly states that in order to assure the independence of the entities listed in the third schedule, the expenditure of each of the agencies shall be financed as a direct charge on the consolidated fund, determined as a lump sum by way of an annual subvention approved by the National Assembly after a review of the entity's annual budget, as part of the process of the determination of the national budget. Wendell Badrie for the HGP Nightly News.